Good afternoon. Attorney Protective would like to welcome you to today's webinar, Calibrating Your Ethical Compass, Navigating Conflicts of Interest. With that, I would like to introduce your first speaker, Erin.
Great. Thank you so much, Michelle. Well, the global pandemic has certainly changed the traditional legal landscape. As the COVID-19 pandemic continues, law firms are adjusting to changing circumstances and client expectations. The effects of the pandemic have also placed more financial pressure on lawyers. To be honest, it still remains unknown, at least with any degree of real certainty, just how the pandemic will impact claims against attorneys going forward. But we know that historically, economic pressures have led to a greater number of claims against lawyers as clients look to point fingers for commercial or other setbacks, whether warranted or not. In the face of this unknown, it can be helpful to look at past quantified data. Ames & Goff, a specialty insurance broker, has issued the results of its survey on legal malpractice claims with 9 leading lawyers' professional insurers. As you can see from the slide, the survey data confirmed that conflicts of interest continue to be the most commonly alleged legal malpractice error. Legal malpractice cases alleging a conflict of interest can be very difficult and expensive to defend. This is because the underlying theory of a conflict of interest, that a lawyer or a firm did not maintain loyalty to clients, typically does not sit well with a jury. Juries sometimes find in favor of plaintiffs even where law firms have followed the requirements of the rules of professional conduct and where they handled potential or actual conflicts in accordance with those rules. In some jurisdictions, punitive damages can be awarded in a legal malpractice action based on conflict of interest. Conflicts are a growing concern today as increasing numbers of law firms seize opportunities for growth and expansion, either through mergers and acquisitions or by bringing in lateral hires. So I think looking at this data and knowing the difficulties and the high cost to defend a conflict of interest claim, it demonstrates why it is important to understand and to be able to spot conflicts out of the gate. We will begin our presentation by discussing the applicable model rules addressing conflicts of interest. And with that, I'm going to turn it over to Cal to review the model rules. Cal?
Thank you, Erin. I appreciate the opportunity to be here today. And welcome to everyone. My perspective in this webinar is litigation. I realize that a number of you may have practice areas in other areas like criminal or family law or estate planning, but the rules that we'll talk about today all apply to all practice areas. All of the states and the District of Columbia have adopted the model rules of professional conduct. It's important, though, that you check your own state or your own jurisdiction's rules, because in many instances, states might add or revise the model rules to reflect some local practice or custom that might be unique to a state. For instance, I practice in South Carolina, and the South Carolina rule that is the counterpart to model rules 1.8 and 1.10 both add additional requirements for South Carolina practitioners. And be sure to check the comments, because some rules will either add a comment or delete a comment. As Erin said, I'll talk to you briefly now about the rules at play and highlight some of the important requirements. We'll discuss some scenarios a little later in the webinar which will help illustrate how these rules work together in the real world. If you have access to your rules of professional conduct, either on your computer screen or your phone or in book form, go ahead and pull those up. It'll be a lot easier to follow along as I discuss these rules. So what rules are at play? It's rules 1.7 through 1.12 and rule 1.18. These are the rules that deal with conflicts and how you identify a conflict. These rules also address how a conflict, once identified, can be waived or resolved, if at all. I'd also urge everyone to look at Rule 1.0, and that's the rule that contains definitions. In the rules we'll discuss today, you'll see over and over the terms informed consent or reasonable belief or writing or written, consult or consultation, among others. And these words and phrases are defined in Rule 1.0. So as you take a look at the pertinent rules, don't forget these definitions, because these definitions can give you a good bit of guidance and may impact the outcome of whatever analysis you undertake. Now, the rules themselves are divided into several sections. Rules 1.7 and 1.8 are the rules that generally address conflicts that arise with current clients. Rule 1.7 is the general rule, and Rule 1.8 deals with specific situations. Let's look at Rule 1.7. Rule 1.7 addresses when a conflict exists in very simple and fairly broad terms. A conflict exists when the representation of one client is directly adverse to another client, or the representation of the client will be materially limited by the lawyer's responsibilities to another client, a former client, a third person, or by a personal interest of the lawyer. Everything else in the rules builds off of this definition. The remainder of Rule 1.7 deals with whether a conflict, once identified, can then be waived. I'll be speaking more about that in a moment, and we'll also deal with waiver when we discuss the scenarios in a few moments. Rule 1.8 takes this analysis one step further and looks at more specific issues ranging from going into business with a client, soliciting a gift from a client. This rule provides guidance on who can pay the lawyer and whether a lawyer can provide financial assistance to a client. And throughout this rule, you'll see the terms informed consent and substantial and reasonable. And as I said a minute ago, remember to keep these definitions in mind and make sure your understanding of what these terms mean is consistent with the definition in Rule 1.0. The situations that are outlined in Rule 1.8 are not issues that arise every day. In fact, you may or may not ever find yourself in any of these specific situations. But when you do, Rule 1.8 is the go-to rule to help lawyers address and navigate these particular situations. Let's move on to Rule 1.9, and that's the next slide. Rule 1.9 addresses duties to former clients as opposed to our duties to current clients that we just addressed. That distinction is very important. The duties owed to a current client are different than the duties you owe to a former client, and we'll see that in practice when we discuss the scenarios in just a minute. The key phrase in Rule 1.9 is the phrase same or substantially related matter. So if you've represented a client in the past, you cannot later represent someone in a matter which is the same or substantially related matter in which the person's interests are materially averse to the former client unless the former clients give you informed consent in writing. And it's critical that the informed consent must be in writing. We'll speak a little further about this rule in a minute, but for now, remember that the phrase same or substantially related matter is very, very important. Rules 1.10, 1.11, and 1.12 all deal with imputing conflicts among lawyers who practice together as a firm. And believe it or not, the term firm is also defined by Rule 1.0. We'll deal with imputing conflicts in greater detail when we discuss the scenarios in a few minutes, but in the meantime, these are the rules that deal with that issue. Looking at Rule 1.10, Paragraph A operates only among lawyers currently associated in the firm. So when a lawyer moves from one firm to another, that situation is governed by Rule 1.10b. When a lawyer joins a private firm after having represented the government, though, imputation is governed by Rules 1.11b and c rather than Rule 1.10. So as you can probably detect by now, these rules are very technical, and so it's wise to review these rules when lawyers join your firm or when lawyers leave your firm. As far as rules among lawyers currently associated together, it's a good idea to read the rule, but the basic premise is that a firm of lawyers is essentially one lawyer for purposes of the rules. The rules basically say that all lawyers in a firm are bound by the obligation of loyalty, and each individual lawyer owes to his or her client. We'll discuss an exception in the scenarios in just a minute, but this is the premise that these rules build on. Briefly, Rule 1.12 deals with situations when a former judge or law clerk joins your firm. And note or remember that this rule always also includes arbitrators, mediators, and other third-party neutrals. The last rule I'll address right now is Rule 1.18, and this addresses duties to prospective clients. And prospective clients are people who discuss with the lawyer the possibility of forming a lawyer-client relationship. For any number of reasons, prospective clients do not always become current clients, but if they've shared information with the lawyer in the course of their communication, this information, under certain circumstances, is given some protection. And as you will note from this rule, prospective clients receive some, but not all, of the protections afforded to clients. But this rule gives you a roadmap to follow in the event this issue arises. Again, we'll talk a little more about this rule when we discuss the scenarios in a few minutes. But in the meantime, realize that 1.18 is the rule that addresses prospective clients. Erin, do you have any comments on that?
No, I think with that, let's shift our focus to some common scenarios that we're seeing in the current legal arena regarding these rules. We will then discuss some lessons learned and then some best practices related to the topics. So to start with, conflicts of interest can arise in several types of settings. We're probably most familiar with conflicts of interest that occur during representation of two different clients, or when an attorney wants to represent one client with an interest that is contrary to the interest of a former client. However, conflicts also arise when the representation of a client will be in conflict with the lawyer's personal interest, which can stem from a personal relationship. As Cal discussed, Rule 1.7 provides that a lawyer shall not represent a client if there's a significant risk that the representation will be materially limited by the lawyer's own financial, business, personal, or other interests. Comment 11 to this rule specifically identifies such a personal interest as when a lawyer is closely related by blood or marriage to opposing counsel. In such a case, the attorney cannot handle the client's case unless each client has given informed consent confirmed in writing. A recent ethics opinion takes it further, warning that lawyers need to take a hard look at personal and casual relationships with opposing counsel that might conflict them out. For example, a lawyer's independent judgment is likely to be materially limited if, due to the personal relationship with opposing counsel, the lawyer would refrain from filing a well-founded motion for sanctions against opposing counsel. Formal Opinion 494 analyzes three categories of relationships: intimate relationships, friendships, and acquaintances. This opinion advises that some relationships with opposing counsel are casual enough that they do not present a conflict issue, but others might obligate the lawyer to disclose such relationships to clients. So let's look at these three categories. Intimate relationships. The opinion notes that changing living patterns suggest more people may be living in the same household with arrangements that do not correspond to traditional categories. The opinion reads that lawyers who cohabit in an intimate relationship should be treated similarly to married couples for conflict purposes. This includes those who are engaged to be married or in exclusive intimate relationships. In those cases, lawyers must disclose the relationship to their respective clients and may not represent such clients unless each client gives informed consent confirmed in writing. The opinion explains that a number of states agree that intimate and cohabitating relationships should be treated like spousal ones, citing ethics rulings from Arizona, Michigan, and North Carolina. It adds that failure to disclose the relationship may result in discipline, disqualification, or other significant consequences. A more difficult question arises for those lawyers who are in a type of intimate relationship but are not exclusive or not necessarily living together. Lawyers in these types of non-exclusive intimate relationships must carefully consider whether the relationship creates a significant risk that the representation of either client will be materially limited by the lawyer's personal relationships. The opinion adds that the prudent course is to disclose such relationships and then obtain the client's informed consent. So moving on to friendships. I believe friendships may be the most difficult category to navigate here because there are so many different types of friendships. Those relationships all need to be examined carefully. the opinion notes that lawyers should affirmatively disclose close friendships with opposing counsel to their clients. These include friendships where the lawyers exchange holiday gifts or spend time at each other's homes routinely or even vacation together with their families. Ordinarily, such close relationships with opposing counsel should not only be disclosed to clients, but lawyers should also obtain clients' informed consent. However, the rule says it's a judgment call. The practitioners must decide whether Rule 1.7 applies and if they can competently and diligently carry out the representation, notwithstanding the potential conflict. So, in summary, opposing lawyers who are friends are not for that reason alone prohibited from representing adverse clients. The analysis turns on the closeness of the friendship. If there is a significant risk that the representation of one or more of the clients will be materially limited by the lawyer's relationships, the lawyers must disclose the relationship to each affected client and obtain that client's informed consent confirmed in writing, assuming the lawyers reasonably believe that they will be able to provide competent and diligent representation to each affected client. If the lawyers can't do so, one or both of the lawyers must decline or withdraw from the affected representations. The third category discussed is acquaintances, which the opinion defines as relationships that do not carry the familiarity, affinity, or attachment of friendships. The opinion describes such relationships as those where individuals see each other at gatherings, such as for a professional organization or church, but don't feel a close personal bond. Acquaintances may be lawyers who meet at bar association meetings or present continuing legal education programs together like we're at today, or even serve on committees or boards together. However, disclosure may be advisable to maintain good client relations. It may be helpful to inform a client that the lawyer has a professional connection with opposing counsel and then explain how it will not materially limit the lawyer's objectivity, but may in fact assist in the representation because the lawyers can work together collegially. So I think the best practice tip to take here would be I would urge lawyers to disclose information that a reasonable client would consider to be significant in retaining counsel. Beyond ethics rules, such an approach would be consistent with the lawyer's fiduciary duty to loyalty and candor. So, Cal, before we move on to our next scenario, is there anything you would want to add here?
No, I think you covered it. You covered it well. It gives us lots of food for thought.
Mm-hmm. Okay, great. Okay, so moving on to our next scenario. There's no doubt that the practice of lawyers investing in clients has become more common in recent years and has been led largely by firms representing high-tech clients. But even when precautions are taken, lawyers are still at risk of being accused of self-dealing. The lawyer who goes into business with a client faces a heavy burden of establishing both informed consent and transactional fairness. Investing in clients' businesses also falls into the class of conflicts involving personal, financial, or business interests of the lawyer that may conflict with those of the client. A good economy and healthy corporate profits do not typically foster an increase in malpractice claims. However, as we discussed earlier, when we see an economic downturn and falling profits, we see a rise in these types of conflict claims. So what are the risks of such investments, and are they worth taking? Rule 1.8a generally permits attorneys to invest in their clients or enter into business transactions if three general requirements are met. One, the terms of the transaction are fair and reasonable to the client and disclosed in writing. And keep in mind, whether the transaction's terms are fair and reasonable to the client's interests will often be viewed from the perspective of the client. That's because there can be an appearance in such a situation that the attorney is placing her or his financial interests above the interest of the client, potentially creating a conflict. So number two, the client is informed of and given the chance to seek independent counsel regarding the transaction. Independent counsel operating with no interest in the transaction allows the client to benefit from professional judgment free of conflict. And additionally, it adds to the likelihood that the agreement will pass muster in the future. And then the third requirement is the client provides written informed consent to the essential terms of the transaction and the lawyer's role in the transaction. Like all conflicts of interest, obtaining a client's informed consent to an investment by an attorney typically involves more than just reporting that a conflict might exist. Many attorneys will ensure that the client's actual consent is disclosed in writing. In practical terms, this may mean that the client signs the disclosure with a sentence added that states that the client has been informed of the risks, advantages, disadvantages, alternatives, and information necessary to assess the transaction, and affirmatively and expressly consents to the transaction. One additional precaution that some will take is the addition of a witness to the client's signature. The most important goal is to eliminate any dispute regarding the client's consent to the transaction. The question that will ultimately be presented to the jury in these situations is whether the lawyer's investment stake was sufficient enough for the lawyer's point of view to impair his or her objectivity. As a practical example, a lawyer representing General Motors is presumably entitled to invest in a mutual fund that invests in General Motors. However, the more material the investment in relation to the rest of the lawyer's practice, the greater the risk of triggering these ethical and legal issues. The fundamental issue is whether the stake is sufficient to impair or to create the appearance that it may impair the lawyer's exercise of independent judgment on behalf of the client. In my own experience with handling legal malpractice claims over the year, I've seen many fallouts when attorneys do business with clients. While clients often invite lawyers to invest with them, lawyers should very carefully comply with the requirements of Rule 1.8. The current rules do not absolutely prohibit a lawyer from engaging in business dealings with a client, but doing business with a client is discouraged and restricted by this rule. And this is because a lawyer's legal skill and training, together with the relationship of trust and confidence between the lawyer and the client, it creates the possibility of overreaching when the lawyer participates in a business, property, or financial transaction with a client. Failure to comply completely with all of these requirements may result in the lawyer's suspension or disbarment, even if the deal is to the client's benefit. So although ethically permissible if the conditions are met, from a risk management perspective, entering into a business transaction with a client is not necessarily a good idea. Cal, is there anything you want to add to investing with clients before we move on to our next scenario?
I just very much recommend having that independent lawyer involved if this is something you want to undertake. Rule 1.8 is the rule that sets out the way this can be done, if at all. But an independent lawyer representing the other side is very much recommended.
I agree. Okay, so moving on to our next scenario. In the virtual world, everyone is a potential client. If a lawyer isn't careful, someone may inadvertently become an actual client, or at least think he or she is, often with grave consequences. The ABA issued an opinion that recognized that by enabling communications between prospective clients and lawyers, websites may give rise to inadvertent lawyer-client relationships and trigger ethical obligations to prospective clients under the rules of professional conduct. It advised that the interactive nature of social media, in other words, inviting and responding to comments to a blog post or engaging in Twitter conversations, this creates a real risk of inadvertently forming an attorney-client relationship, especially when the objective purpose of the communication from the consumer's perspective is to consult with the lawyer about the possibility of forming a lawyer-client relationship regarding a specific matter. In other words, if a person asks a legal question and a lawyer answers or says that he or she will look into it, a lawyer-client relationship may result, regardless of a signed engagement letter or even a formal handshake. To avoid incurring unwanted obligations to prospective clients, lawyers should either discourage unilateral emails or urge would-be clients to avoid communicating sensitive information until the lawyer has done a conflicts check. These precautions can be taken both in general advertising and on the lawyer's website. Again, the attorney-client relationship does not have to involve a face-to-face meeting or a signed engagement letter, so an attorney should be especially careful that an email exchange does not turn into an attorney-client relationship unless you want to take on that client. Depending upon the ethics rules in the jurisdiction where the communication takes place, use of appropriate disclaimers in a lawyer, their law firm's social media profiles, or in connection with specific posts may help avoid inadvertently creating these attorney-client relationships, so long as the lawyer or the law firm's online conduct is consistent with the disclaimer. So when using social media, attorneys should not only speak in generalized terms, but also post explicit disclaimers stating that any interaction does not form an attorney-client relationship in order to inform the user and ultimately rebut any reasonable belief that one exists. Because once a person becomes a client, even inadvertently, it triggers all of the obligations of the attorney-client relationship: loyalty, competency, diligence, and confidentiality. Lawyers who aren't careful to avoid inadvertent clients may face malpractice claims, disqualification, or even worse. There's actually an ethics opinion that came out of D.C. which discusses how expressing your opinion via social media can create a conflict. If you like a political post or tweet a comment on a controversial legal topic, are you potentially creating an ethical conflict of interest with your clients who may have contrary interests? The District of Columbia Bar Ethics Committee thinks so and warns about the risk in its opinion 370, which was issued recently. It's one of the first ethics committees to single out blogging, tweeting, or commenting as having the potential to raise a positional conflict with a client. Such a conflict can arise when a lawyer takes one position and then takes an inconsistent position on behalf of the client. The D.C. committee said, "Caution should be exercised when stating positions on issues on social media, as those stated positions could be adverse to an interest of a client, thus inadvertently creating a conflict. Rule 1.7 states that an attorney shall not represent a client with respect to a matter if the lawyer's professional judgment on behalf of the client will be, or reasonably may be, adversely affected by the lawyer's own financial, business, property, or personal interest. Content of social media posts may contain evidence of such conflicts." This D.C. opinion makes the point that what you say online can put you in an awkward spot with clients or potential clients. Being identified in a high-profile way with a particular position could certainly cause a client to fire you or not hire you. So that's certainly something to keep in mind when sharing on social media sites. On slide 10, we're still talking about conflicts arising from social media and technology usage. And as we just discussed, how the formation of an attorney-client relationship is frequently judged from the reasonable perspective of the putative client, not from the subjective or even reasonable belief of the lawyer. And if a lawyer isn't careful, someone may inadvertently become an actual client. So I think it's important to just quickly review the importance of the engagement letters and also non-engagement letters. Your engagement letter sets the parameters of the attorney-client relationship. It's probably the single most important document that defines the attorney-client relationship. It's a smart move to use them even if they're not required in your jurisdiction. It protects both the lawyer and the client. It makes the relationship clear to the client. It helps the client to value the relationship and really take a look at the lawyer's work seriously. However, they're only as good as they are specific, and there is a hesitancy to invest a lot of time into them. You'll see on the slide that I outline what needs to be in it, and I'm not going to read it just because it's obviously available on your slide, but you might want to take a look at your engagement letter and make sure it's hitting on all of these points. There's also a case on the slide that highlights an example of why having such a well-crafted engagement letter is so important, and I encourage you to read it if you have time. In many instances, lawyers are also sued by non-clients or by those who are considered by the lawyer to be non-clients, as we've been talking about regarding conflicts with social media and email usage. Without a fee, without a commitment to representation, and sometimes with even not having offered any real legal advice, an attorney can become the subject of a malpractice suit. And this is because the determination of whether or not the attorney-client relationship existed is based on the client, or in this case, the non-client's reasonable belief and perceptions. And this is where a non-engagement letter can really help you. A non-engagement letter gives you the opportunity to emphasize that no advice was rendered and that the prospective client should not rely on anything you or a member of your firm said during the preliminary conversations. This helps to avoid a potentially costly misunderstanding later down the road. It should include It should specifically state in the letter that you are not able to accept the case. It's not necessary to give a reason for declining the case, but if you wish to do so, you can. It should touch upon, avoid commenting on any of the merits of the case. If you're not taking the time to research and investigate the case, you shouldn't offer an opinion as to its worth, and this is particularly true if you're not skilled in that area of law. If time limits apply to their case, generally advise that the client, that there are time limits that apply. However, I would not recommend specifically stating your calculations for the time limitations. I would just instead emphasize that it's imperative to consult with another lawyer as quickly as possible. And I would consider sending a non-engagement letter by certified mail, return receipt requested, and then certainly keep a file of all non-engagement letters in a miscellaneous file, and be sure to enter information concerning the declined potential client in your conflict system. You'll see on the next slide that I've just included an example or a sample of a letter here, and that's because I get asked a lot about these as far as non-engagement letters. Should you incorporate them into your practice? I would highly recommend it. And as you can see from the example, they can be short and sweet. And if you're looking for more examples of these, you can find sample non-engagement letters at the website that I listed on this slide. Cal, before I move into our next scenario, is there anything you want to add to conflicts regarding social media usage?
Well, one thing that I think is important is also to have an end of engagement letter, because that separates a current client from a former client, and for purposes of the rules we discussed earlier, that makes the division line very clear. And an end of the engagement letter can be as simple as, I've enjoyed working with you. This letter confirms that our engagement is over or ended, just to make sure that the client is aware that you don't have a continuing obligation if the matter is in fact over. Okay,
great. Okay, so moving on to our next scenario. As the nation continues to deal with the effects of the pandemic and what it has done to our economy, lawyers and litigants may be looking for ways to protect themselves and their assets. One topic that has been the subject of significant commentary in recent years, and even more so in the throes of this pandemic, has been litigation funding. Initially, most financing was done on a single case litigation. This meant that the provider had to do a deeper due diligence as the risk was all tied up in one case. They needed a high degree of confidence in both the case and the litigating firm before deciding to fund the matter. More recently, though, these providers have shifted towards funding portfolios of plaintiff litigation. This allows for less risk, easier diligence, and a higher level of funding. The providers in these scenarios will provide a set amount of funding to cover multiple cases with stakes in each case outcome. This obviously mitigates the risk of any one case becoming a loss. Although litigation funding arrangements can take on many different forms, in most instances, a third party, such as a litigation funding company, pays a litigant's attorney's fees and other costs in exchange for an interest in the outcome of the lawsuit. Litigation funders assess the strength of litigation as an investment. In this way, litigation funding can provide access to justice for litigants that otherwise couldn't afford it, or can help minimize the risk for litigants by sharing the costs and the risk with a third party. Of course, at the end of the day, the client also has to share legal compensation for real loss with third parties who have no connection with the dispute. However, in many cases, compensation would never have been obtained without the funder's help, especially where smaller and less certain claims are concerned. Experts expect to see a flurry of litigation funding activity in the aftermath of COVID. This is because clients and law firms alike may be experiencing cash shortages or layoffs as a result of pandemic-related issues. Working with a litigation funder can help ensure that law firms are paid in real time for their work, and to help ease the burdens on cash-poor clients to pay legal fees during financial duress. Even large corporate clients can therefore be freed up to generate cash flow and to let funder finance their litigation, which litigation itself is an asset and can be a revenue-generating enterprise. So lawyers should be alert to potential conflicts of interest issues when working with third-party funders. If the law firm has an attorney-client relationship with the funder based on other representations, or if they might benefit financially from a litigation financing agreement between the funder and another client of the firm, or if they anticipate that the funder will finance future cases of the firm, or if they receive a referral fee from the funder. To assure compliance with the conflict of interest rules, law firms should not accept a referral fee from a litigation funder. Moreover, counsel should carefully consider whether any existing relationship between the law firm and the litigation funder prevents counsel from giving their best advice to litigants that they represent. So an attorney whose client is contemplating litigation financing should also consider what the client may think about the conclusions of the litigation, including, for example, whether the client is likely to be upset about the percentage of recovery that the funder receives if the litigation is successful. So there's lots of ethical considerations here, but I would say that this is certainly something that we're going to see more of. And although the area is certainly controversial, courts are allowing the use of financing agreements, and the American Bar Association has reviewed the issue and concluded it does not involve any per se ethical violations, but cautions attorneys to be mindful of their professional obligations to clients, including their obligation to maintain confidentiality and avoid conflicts of interest. The next scenario deals with switching firms and lateral hires. And the COVID pandemic has sent the U.S. economy, including the legal industry, into upheaval. And as the country begins to slowly emerge from the pandemic, thousands of attorneys will be looking to move to new law firms and create their own, bringing clients with them and creating the potential for conflicts of interest at their new firms. In these changing times, it's more important than ever to avoid conflicts of interest that could lead to disqualification from representation or even malpractice. For example, lateral hires could bring with them conflicts of interest that could ultimately disqualify a firm from representing current clients. For example, say there's an attorney moving to a new firm with information about client D, a client of hers at the old firm, in a matter that is substantially related and materially adverse to the matter being handled by the new firm on behalf of client P. Well, once that new attorney joins the firm, her knowledge about D is imputed to the other members of the firm, thereby creating a conflict under Rule 1.9 that might result in the new firm's disqualification from representing client P. Cal touched a little bit upon this, but the rule of imputed conflicts of interest seems to work well in the context of smaller mid-sized law firms where lawyers within the firm may have direct access to or actual knowledge of confidential information about another client's about the other client's representation. It becomes more problematic in larger firms where, as a practical matter, lawyers within a firm may not have access to confidential information about a client represented by a lawyer in a distant office. So when you're looking at lateral hires, you want to make sure that you're taking the appropriate precautions. And I would say as lateral hiring continues to climb, many jurisdictions that permit it, they permit these ethical screens. You want to make sure that you're abiding by the rules. The lawyer receives no fee from the matter is one of them. Written notice is given to former clients notifying them of the screen. A statement that the review of the screening procedures may be available before the tribunal. An agreement by the firm to respond promptly to any inquiries by the former client. All of these things need to be followed. And it's critical that law firms implement due diligence procedures to ensure that the lateral attorney identifies and reports to the firm all existing client matters that the lateral attorney is bringing to the firm. So keep this in mind when dealing with your lateral hires. You don't want to end up in a position in which the firm has to part with two clients, an existing client and one that came with the new lawyer. And you certainly don't want to find yourself facing a malpractice claim due to these kinds of conflicts. So with that, Cal, I'm going to hand it over to you to talk about your different scenarios.
Okay, let's switch to the next slide. And we're going to talk now about a few factual scenarios and how these rules might play out in the real world. You can let's look at the slide on the screen now. You can read the specifics of this conflict, but this first scenario involves a situation where one lawyer is advocating through a board for the preservation of a historic structure. The potential client owns the building and wants to hire the lawyer's firm to help find a way to destroy the building. In other words, the potential client and the lawyer who serves on the board for the preservation group are in opposite camps and take opposite positions in this particular issue. So what sort of analysis should we do here? I think the first place to look is Rule 1.7. This is not the typical situation where two entities are directly averse to each other in the same transaction or litigation. Making that assumption, I would submit that this scenario could create a conflict for the lawyer serving on the board of the preservation group, because potentially there's a significant risk that the representation of the building owner would be materially limited by the lawyer's personal interest in historic preservation. And that is exactly what is addressed in Rule 1.7A2. Now, whether that lawyer's personal interest truly rises to the level that it would be materially limited in a case in this case is a unique situation. You take these things on a case-by-case analysis, but the optics here don't look good. So in an abundance of caution, if I were the lawyer on the board, I would decline that representation. That leads to the question, though, can a different lawyer, can one of the lawyer's partners or associates in the same firm assume the representation? And put another way, if the first lawyer is conflicted by a personal interest, would that lawyer's personal interest be imputed to another lawyer in the firm? As a general rule, as we've just discussed, a conflict for one lawyer in a firm is a conflict for all lawyers. But Rule 1.10, and this is the imputation rule, has two exceptions, and one of those exceptions is a conflict created by a lawyer's personal interest, which does not present a significant risk of materially limiting the representation of the client. So depending on the circumstances, I think this representation could be accepted by another lawyer in the same firm and not be impacted by the first lawyer's personal interest. Erin, do you agree with that?
I do. I agree.
All right, let's move to the next scenario. This, again, you can read the specifics on your screen, but this is the classic question of whether a lawyer or a law firm can dump one client in favor of a more profitable client. And in this case, as you can read on the screen, a one-time small collections case is the only thing standing in the way of a really financially lucrative new matter. As an initial matter, this situation does create a conflict under Rule 1.7. The firm would be representing two clients that are directly adverse to each other in a proceeding. And for purposes of Rule 1.7, it doesn't matter if the representation involves two separate matters. But in this case, the conflict can be waived by following the procedure outlined in 1.7b, assuming that all of the subparts of 1.7b are met. You should always look at these subparts carefully when considering whether a conflict can be waived, but here the representations are so different, I would submit that this is easily a waivable conflict. And as a waivable conflict, these lawyers should go through the process of a waiver by informed consent in writing. We've talked about that earlier, about the best practices of doing that. But the next question in this scenario, at least in my mind, is what happens if the client in the small collections case doesn't waive the conflict? One option is to seek out a different lawyer in a different firm and substitute counsel with the client's consent. In other words, transfer the case to another firm. A second option is to consider terminating representation pursuant to Rule 1.16. That rule allows a lawyer to withdraw as counsel if the withdrawal can be accomplished without material adverse effect on the interest of the clients. Of course, a motion or this process requires a motion and permission by the court, and if the court orders that you continue the representation, then obviously you have to comply. And that particular scenario is discussed in greater detail in Rule 1.16c and 1.16d. So in short, the easiest path by far is a conflict waiver or a consent substitution of counsel, but all hope is not lost if neither of these options are available, because you can take these other steps that might allow you to assume the second representation. Erin, what are your thoughts about that scenario?
Yeah, I agree with you, and I think most importantly, too, is in assessing whether to seek consent to a potential conflict, you really want to look at the practical and business issues as well as the legal and ethical considerations, like what will the client think of this, you asking them for this? So that's just something else to think about outside of the ethical rules.
Right, exactly. All right, let's move to the next scenario, and this one is a tricky one. The issue in this scenario involves using an expert in one case and opposing the same expert in a different case. In many practice areas, as many of you know, there's such a small pool of experts that choices are really very limited. My gut reaction on this scenario is that there could be a problem if you are limited by how you either present the expert or how you cross-examine the expert because of your duties or responsibilities to another client. If that limitation meets the standard of Rule 1.7A2, then there could be an issue. Suppose you might challenge the expert's credentials or manner of operation on cross-examination. If you forego these opportunities because it might impact how you use that same expert in representation of a second client, that could be that significant risk of representation of one or more clients being materially limited by your responsibilities to a third client. And I think this scenario is really fact specific, so it's difficult to really give any kind of blanket answer. Presumably, in the real world, the expert would have notified the other side of his or her association with the first lawyer, but it's food for thought, and it does illustrate the second part of Rule 1.7A. Erin, what's your reaction to this scenario?
Yeah, I agree with you. And this is something, like you said, there's only a small pool of experts sometimes. So this is certainly something that comes up. And like you said, Cal, this is, I think, food for thought. And just keep in mind, Rule 1.7A2, if you do have an issue like this that you're confronted with.
All right, let's move to the next scenario, and this one involves prospective representation, and Erin talked about that a little earlier, but this is a scenario that illustrates it in the real world. In this case, you discuss a potential client's case in a very general way, no agreements reached, and then you are later contacted to represent the opposing party in the potential client's case. And that's the classic case addressed by Rule 1.18, Rule 1.18. Bottom line is that you can have that general conversation about a case and then take the other side. But what you can't do is receive information from the prospective client that could be significantly harmful to that person in that matter. So that's the reason that you should, as a matter of practice, receive only the general information that you can use to determine whether you'll take the case. And that was talked about in greater length by Erin a little earlier. Even if you receive disqualifying information, another lawyer in your firm can take the case so long as you're walled off and you're not apportioned any part of the fee that comes out of that case. And the details on that piece of the scenario are in Rule 1.18. Erin, you have anything to add to that?
No, I think you covered everything. I would just reiterate that to the greatest extent possible, lawyers should use communications with prospective clients to obtain only the information reasonably necessary to determine whether they can represent the prospective client.
Okay. All right, let's move to the last scenario. And this scenario involves former representation. And the rule at play in former representation is Rule 1.9. And so in this scenario, a lawyer represents someone in a divorce action. And then 3 years later, the same lawyer is asked to be adverse to the company, and his former client serves on the board of that company. Is this a conflict? Well, I'd submit that the answer is no. The matter is not the same matter, and it's not substantially related to the divorce action. And the former client is merely on the board of the adverse party and is not the adverse party himself. I don't see any problems with that representation. Now, it gets trickier in the second part of the scenario where the facts change and the suit involves a claim against a former client on a guarantee. In this case, the lawyer should carefully consider whether he or she obtained financial information or any other information in the divorce that could be used against the former client in the new suit. So if the lawyer obtained this type of information that is not public, Rule 1.9 prohibits a lawyer from using information relating to the representation to the disadvantage of the former client, even if the matters are not related. Again, there's no blanket answer here other than it depends on the specific facts, the information that was obtained in the former representation, and the passage of time. Much can change in 3 years. But again, it's food for thought, and it illustrates Rule 1.9. Erin, do you agree with that?
I do. I agree. And just one thing I would say that I've seen issues with continuous representation when the firm thinks the matter is concluded and the client is now considered a former client. Meanwhile, the client believes they're still a current client. So just in looking at this rule, I would say I would recommend the use of termination letters to make it clear that the client is indeed a former client instead of a current client.
That's exactly right. That illustrates exactly why those end of engagement or termination letters are important. All right, let's move to the next slide. And what the next part of the webinar is when you think you have a conflict of interest, what should you do next, or what are the steps you should take? The first step, as you can see on the screen, is confirm you have a conflict, that a conflict actually exists. I'd read the rules we've discussed today and keep them available. In today's world, there's no reason that the rules, can't be available to you electronically 24/7. So, first, item number one, read the rules. And if you've read the rules and you're still uncertain that a conflict exists, I then suggest that you look at any number of outside resources. The ABA, most state and local bar associations all have resources to help lawyers determine whether a conflict exists. These include helplines, ethics opinions, professional responsibility committees, and many other resources. All jurisdictions have disciplinary offices, whether it's in the Supreme Court or an independent organization, that routinely issue disciplinary opinions that might apply to your situation. And most, if not all, of these type of opinions are available online. Another option is if you practice with other lawyers, talk with them. Some large law firms have in-house ethics committees that address conflict issues. Don't forget about the comments to your state rules as well, because these can be very helpful in determining whether conflicts of interest exist, particularly in the rules we've discussed today. Also, seek advice of a person who is detached and has no interest one way or another, and that person can almost always provide you a more objective opinion. You've seen through our discussion of these scenarios that conflicts can arise in many ways through circumstances other than two clients simply being averse to each other. Keep in mind that business clients, the personal interests of lawyers that we discussed, new parties that come into the case later, key personnel, issue conflicts, and former representations are all potential landmines, and you should be aware of those and take those into account. These should all be considered as you think through whether a conflict exists. If you've gone through this whole analysis, you've talked to somebody, you've consulted resources, you've looked at this carefully, and you can't rule out that a conflict exists, I would proceed as if a conflict does exist. In other words, if you're in doubt, assume you have a conflict. Once you think you've discovered a conflict, the next step in the process is to determine whether it can be waived. Not all conflicts are waivable, but many conflicts can be waived if the condition listed in Rules 1.7b and 1.9 are met. I'd read the subparts of these rules very carefully and consult the resources I just mentioned. Again, remember that all of the conditions listed in the rules must exist for the conflict to be waivable. The analysis is and it's not or. The other key piece of this is that the analysis, for the most part, is based on judgment calls that we make as lawyers. I think the better practice, like determining whether a conflict exists at all, is to resolve all doubts in favor of the client. So if you have doubt about whether a conflict exists, you probably have a conflict. If you have doubt about whether a conflict can be waived, it probably can't be waived. So let's assume that you have a conflict. What do you do next? And I think the next step is to immediately inform your client. If you have determined that the conflict exists but it can be waived, you should inform the client that a waivable conflict exists. Most jurisdictions' rules of professional conduct require informed consent in writing for a conflict waiver, as we've discussed throughout this webinar. And to understand your responsibilities in this situation, you should make sure you understand how your jurisdiction defines informed consent. Again, this is back to that rule of Rule 1.0 of the definitions, but subparagraph F defines informed consent as, and I'm going to read it to you, the agreement by a person to a proposed course of conduct after the lawyer has communicated reasonably adequate information and explanation about the material risks of and reasonably available alternatives to the proposed course of conduct. Comment 6 to Model Rule 1.0 explains in greater detail, when you obtain informed consent, be sure that you put as much of the communication as possible in writing. And as we've also said earlier today, it's also wise to urge or advise the client to obtain independent counsel if desired, if they so choose to assist in determining whether they should waive the conflict. All of those are very important steps. If the conflict arises and the formally represented party is an adverse party in litigation, you should inform opposing counsel and request a waiver from the opposing party through counsel. Opposing counsel can then consult with their client and determine whether the opposing party is willing to waive the conflict. Again, you need to put as much of this communication with opposing counsel in writing and explain the nature and scope of the conflict as clearly and in as much detail as you can. You just don't want the opposing party to waive the conflict and later claim that you didn't fully disclose the nature of the conflict to opposing counsel. As the next slide indicates, if any party refuses to waive the conflict and you're in an ongoing litigation, then you should inform the court immediately that a conflict has arisen and that you must withdraw from representation. Your client should then move quickly to hire a lawyer to replace you, even if the court grants you a longer period of time to do that. After you inform the court, you should make sure that your client is protected from immediate deadlines. This can be in the form of consulting with the court in writing or reaching some agreement with opposing counsel. Some jurisdictions have fee-lien provisions that do not require a lawyer to transfer a file until all outstanding fees are paid, but I think it's a much, much better practice to immediately transfer file materials to the new lawyer and consider the accounts receivable a separate issue. If the conflict arises and is not waived before you make an appearance with the court or the matter is not in litigation, you should either decline or terminate representation in writing immediately. While you should take prudent steps to protect your client's immediate needs, you must cease representation as soon as practical once that conflict has been identified and it cannot be waived. And finally, if you determine that a conflict exists that can't be waived, you should skip the steps relating to waiver and simply follow the steps above to inform the client and immediately withdraw or terminate or decline the representation. As I mentioned earlier, speed is very important so that the chance of any prejudice to the client is minimized, and that's a key consideration in declining representation or dealing with a conflict of interest. Erin, do you have any comments on any of that?
Yeah, I would just say the final thoughts really here are, as Cal said earlier, it's a good idea to keep a copy of the rules we just discussed handy and then read the rules each time you think you could potentially have a conflict. There are apps out there, there's links, there's websites that contain all of these rules so they're readily available for you. And if you read the rules and you're still uncertain whether a conflict exists, you should reach out to other resources such as the ABA, or there's ethics hotlines at most state bars. Read ethics opinions, contact disciplinary offices. It's also a great idea, Cal mentioned this, to run the situation by another lawyer. They'll be more objective than you are. So I would say if there's a conflict, instead of second guessing it or just moving ahead, I would say definitely take out these rules and make sure you're reading them and following everything to avoid a potential conflict of interest malpractice claim. With that, I am actually going to hand it back over to Michelle to open up our Q&A. Michelle?
Great. Thanks, Erin. Thanks, Cal. Great information. I'm just relaying from the comments that have come in already that people have enjoyed this presentation. Question that just came in: if a prospective client contacts you to evaluate their case but you do not take the case, are you required to send them information on the statute of limitations?
Yeah, I'll take the first stab at this. So it's a great question, and we talked about non-engagement letters during the presentation, and this is where you would advise a prospective client that you're not taking their case. In this communication, it's not necessary, as I said, to give a reason for declining the case. You may choose to do so if you wish, but you should avoid commenting on the merits of the case. If time limits apply to the case, I would suggest generally advising the client that time limitations apply. However, I wouldn't recommend specifically stating your calculations for the time limitations. Instead, I would say emphasize that it's imperative to consult with another lawyer as soon as possible. Cal, do you have anything to add to this?
Yeah, I mean, that's the classic Rule 1.18 analysis. And I think you're right. I think you advise them that there are limitations, time limitations. And I think the sooner you can process the potential case and decline it, the better off you are. That's just not as much opportunity to take up to hold the case, have the ball. So the sooner those things can happen, the better off you are.
Super. Thanks, Cal. Okay, so the next question is, what is the best course of action if a non-waivable conflict emerges right before an important deadline and immediate withdrawal would prejudice the client?
I'll take a stab at that. You definitely don't want to prejudice the client, but at the same time you want to move with speed, as I mentioned earlier. So if the deadline can be extended, I'd ask for an extension. And I guess this question, I'm not sure what scenario this question would be, but if it's one that's a court deadline or a deadline that opposing counsel can grant an extension, I would certainly do that. If it is a litigation matter and a court's involved, you can always request a status conference and seek permission to extend whatever deadline by the court. But I guess the real question here is what happens if the deadline can't be extended, if it's one that is maybe a tax deadline or a government deadline or something where you just can't get an extension. I think the better course of action is to do what you can to protect the client, not prejudice your client, and then move as quickly as you can afterwards to get out of the representation. And I try to be as transparent along the way as I could and inform the opposing counsel if you're in litigation or another lawyer on the other side of what you're doing. Erin, what do you think?
Yeah, no, I think that's a great answer, Cal. I think you covered everything.
Great, thank you. Okay, question. As a quick reminder, we are past the 60-minute mark. It's not necessary to stay on the line to receive credit for today's webinar. We do have some other great questions coming in, though, so we'll roll through a couple more of those. Are there conflicts involved with a lawyer being involved in a family business and also providing legal services to that family business?
I think we touched on some of this during the webinar. I think that is Rule 1.8A. Obviously, that depends on the role you play in the family business and the role you want to play as a lawyer. I think that as a lawyer, Rule 1.8A gives you the pathway to be able to navigate that question and that situation. I think I'd take a look at that rule and just follow it as closely as possible. Erin, what's your reaction?
Yeah, I agree with you, Cal. This is definitely a place where Rule 1.8A would come in. And again, that rule generally permits attorneys to go into business transactions with their clients, but there are those three general requirements that we talked about, one being that the terms of the transaction are fair and reasonable to the client and disclosed in writing. The second one being that the client's informed of and given the chance to seek independent counsel regarding the transaction. And the third one, that the client provides written informed consent, or the client provides written informed consent to the essential terms of the transaction and the lawyer's role in the transaction. So if you're in a situation like this, like Cal said, I would make sure that I'm complying with Rule 1.8A.
And depending on the size and extent of the business, I think getting another lawyer involved to guide the company would be helpful as well.
Very good. Okay, another question is, can you represent husband and wife in a divorce if they both agree to waiver?
I can take the first stab at this one.
Okay.
I guess the short answer is no. Lawyers are expected to, of course, abide by ethical rules when they practice law, and one of these rules is that an attorney can't represent both sides during a lawsuit, and that would include a divorce here. And really the reason for this is that an attorney is expected to work in the client's best interest, right? So if an attorney is working for both sides, it's impossible for him or her to be an objective advocate for either client. Even when two spouses agree on everything in the divorce, they're still considered by the courts to be on opposing sides. So that would be my response to that. Cal, do you have anything you would add to that?
Yeah, no, I would stay away from that. At least under the rules, as the rules are written, that's not allowed. Now, I say that coming from a perspective that is not family law. I don't do family law. But, I can't imagine a situation where one lawyer can actually objectively advise two separate clients who are opposing each other in the same proceeding. So I would stay away from it.
Super. Thank you, Erin and Cal. So last question, sort of tied to the same thought process. Would you recommend a conflict of interest letter for a married couple when drafting their estate planning documents?
This is a little different in that a married couple drafting estate planning documents are on the same page. Typically, they want the same thing, but there are circumstances, and I am assuming here, where they have different interests, and in those cases, I think some of these conflict waiver issues that we talked about need to come into play. What about you, Erin? What's your thought on this one?
Yeah, I would agree. This is a different scenario than the one about the divorce. And like Cal said, you can do this if the interests are aligned and you get the appropriate waiver. From a practical standpoint, I've seen issues develop later down the road when there's a dispute about the estate planning documents, and then the lawyers called in and one party's claiming that the interests weren't necessarily aligned, and that they should have been told to seek independent counsel or different counsel. So I think whenever you're dealing with a situation like this and you're trying to represent a married couple, it can get a little sticky. So I would say just be careful, make sure you're documenting everything in the appropriate way, because when you are dealing with family matters and especially estate planning documents, it can get a little tricky and a little hairy.
And I'm sure this is a case-by-case, because I know there are other estate planning scenarios that involve people who have different interests. There may be the second marriage, or one spouse has beneficiaries that the other spouse doesn't, or something like that. So I think this is one that would take an analysis on that case-by-case basis.
Very good. Thank you so much, guys. At this point, we are out of time for further questions. That will conclude today's events. Certificates of attendance will be emailed to participants within 1 week. On behalf of Attorney Protective, I would like to thank all of you for joining us for today's webinar. I would also like to send a special thanks to our speakers, Erin and Cal. Everyone have a great day. Thank you so much.
Thank you.